Just this corner is alleged because we have so many witnesses that I forget their names. Yeah. So I leave a cue.
Do you need another table or something?
I mean, I'm using this chair, if there was.
Sorry, you're free to.
Okay, thank you.
The table.
Thank you.
The easels are here for our use.
I don't have anything. Okay.
Just need to adjust.
Right. Thank you.
You can get one of those.
Okay.
Those are
Those
separate.
are smaller.
No, it's actually pretty light, strangely.
I have a few that doesn't have wheels.
That's right.
Peter Valberg. That's it, that's a simple question.
There's one here. So,
Nick, do you know who is on deck?
Oh, sorry.
Right. He's at the plate.
baseball field. We had confusion in the ranks.
Can you hear in the back? Turning out for your colleagues returning. Sorry? Are your colleagues returning? I hope so. Mr. Dingle, or do we need to wait for Mr. Fallon?
No, he's got another matter yesterday.
Okay. Back on the record. Would the applicant please call its next witness?
The applicant calls Peter Valberg.
Good afternoon, Dr. Valberg.
Good afternoon.
Do you swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
I do. Dr. Valberg, please state your full name for the record.
Peter A. Valberg.
Did you provide written testimony in connection with this proceeding?
Yes.
On behalf of whom?
On gas transmission.
And you have a copy of it in front of you?
Yes.
Does it include any exhibits or references?
Yes, it includes 3 exhibits.
Could you just describe what those are?
The first exhibit is my resume. The second exhibit, which is referenced in my testimony, is examples of lifetime risks and other causes of death and illness. And exhibit C are some examples of air toxics concentrations that are similar to what we're dealing here with the compressor station.
Did you sign your testimony under the pains and penalties of perjury?
Yes.
Do you have any corrections to make in your testimony?
Yes, I have just 2 corrections. They can be found on page 13. They deal with points 43 and 44, and those numbers need to be changed. In line 43, those numbers should be changed to 130 to 150. That's in point 43. And then in point 44, the number in the first line should be 45.
Other than those, with those corrections, do you adopt your written testimony as your testimony in this proceeding?
I do.
Thank you.
Dr. Valberg is available for cross-examination.
Good afternoon, Dr. Valberg. Is it Valberg or Valberg?
Makes no difference. Okay. Yes, good afternoon.
My name is Bryan Bertram. I'm here representing the town of Weymouth. Let's start actually in paragraph 1, the last sentence. You describe yourself as a principal and health scientist at Gradient. I have a pretty good idea of what a principal is. What do you mean when you use the phrase health scientist?
A health scientist primarily is someone who is involved in what I describe later on. It has to do with human health risk assessment, and it has to do with how you as a human might encounter various chemicals in the environment and whether or not the concentrations and durations of those chemicals are going to be harmful to health.
Okay, so it just refers back then to your qualifications on risk assessment. It's not something different?
That's correct.
Thank you, sir. So let's turn to paragraph 10 of your testimony. That's the paragraph that you put under the section, the purpose of my testimony. Is it fair to characterize that paragraph as saying that you were retained to review the state's AALs and TELs?
Yes, and in addition, it probably should say that I was asked to respond to testimony that was filed by other parties.
Okay, those are the rebuttal sections at the end of your testimony, correct?
Correct.
All right, and with those 2 general descriptors, that was the scope of what you were retained to do. Is that correct, sir?
I believe that covers most of it I can think of right now.
Okay. And so you were not retained then to conduct your own independent risk assessment for this project, were you, sir?
No.
And you did not, in fact, do so, correct?
No.
You had a number of footnotes throughout your testimony reciting various papers and other policies, that's correct?
Yes.
You did not have a list of things that you consulted when preparing your testimony. Is it fair to say that the footnotes stand in place of such a list?
Yes, they stand in place of such a list. And of course, when I refer to rebuttals, then of course that refers to the individuals who submitted the testimony.
Okay. If we add together then the aggregate list of your footnotes and then the testimonies you reviewed in rebuttal, is that the complete universe of materials you reviewed in preparing this testimony?
I think that pretty much covers it. I mean, I did in fact look at the Mass DEP air permit, in this case, the air permit approval. And so I'm aware of what some of the issues are in that regard, but I didn't specifically include that as a citation.
If we include that as a citation, is there anything else that comes to mind?
Well, as other witnesses have stated, I mean, I'm of course relying on my background in human health risk assessment and biology and human physiology and so forth.
I understand that. That makes perfect sense. Let's move ahead then to paragraph 13 of your testimony, if we could. In paragraph 13, is it fair to say that you describe what you view as the majority of human cancers, the different means and manners from which they may arise? I think you list 3.
Yes, that's correct, and I think that they're pretty broadly accepted as the sources of human cancers.
We can agree that sometimes cancers can arise from exposure to chemicals, correct?
Sometimes they can, correct.
And formaldehyde would be such a chemical, correct?
The question with formaldehyde is whether or not there really is a dose response, but it is currently classified as a human carcinogen. That is correct.
We go down towards, we're still in paragraph 13. We go down towards the end of that paragraph. You wrote, US EPA generally considers calculated residual lifetime cancer risks in the range from 1 in 10,000 to 1 in a million to be acceptable. Did I read that correctly, sir?
Yes,
This is a Mass DEP proceeding, correct?
correct.
And reviewing the AALs and the TDLs, you understand that Mass DEP has set the acceptable risk level at 1 in a million, correct?
Yes,
And that, sir, is the standard that applies here, correct?
that's the standard that they use to set the AALs.
That's Mass DEP's best judgment of what the risk should be, true?
That's the risk that they chose to set the AALs for the purpose that they're used.
Yes. Are you familiar with the concept of NTL as it's used in the AALs and the TDLs?
Yes.
Could you just briefly describe what that is, please?
That's a no threshold effect level, and that is essentially what they begin with when they start deriving the AALs.
Okay. And it reflects cancer risk, correct?
Correct.
And there's one for formaldehyde?
Yes,
That represents the AAL in the case of formaldehyde, is that correct?
correct.
Let's skip quite a bit ahead, actually, to paragraph 66 of your testimony, if you could. Once you're there, please look up and see if you wrote it.
Yes, I have 66 on page 17.
That's correct, down near the bottom.
Yeah.
In that paragraph, are you speaking only to the TDLs or the AALs too?
Well, on 66, what I point out is that the AALs and TELs are used in the context of permitting, and they apply to the incremental risk provided by a specific facility. And what I'm saying there is that if one were more interested in terms of what actual 24-hour or annual average concentrations are in the ambient air, there are a number of other agencies that grapple with that problem and have in fact provided some guideline levels that would apply in that circumstance, which is not a permitting circumstance.
Help me out, where's AAL in that paragraph?
Well, I think that I use the word TELs in there, but you're right, there is no AAL in that paragraph.
But it applies to the AAL now as your testimony.
No, what the subsequent guidelines are that are in points 67, 68, and 69, they have to do with concentrations that are more comparable to the TEL because they have averaging times that are in the region of 1 to 7 days.
So is it your testimony that paragraph 66 applies to the AAL?
Well, the other agencies that we discuss in this paragraph, or that I discuss in this paragraph, also have developed cancer potency factors. And so those developments have also been used by Mass DEP to develop the AALs. But those are, as you mentioned earlier, are specifically for cancer risk calculations.
I understand that. I'm just trying to get a clear record. Does paragraph 66 apply to the AAL or not? Yes or no?
No.
In the first sentence, you use the phrase more appropriate. Sir, are we sitting here today at a Mass DEP proceeding?
Yes.
This is for a Mass DEP plan approval, correct?
Correct.
Mass DEP applies Mass DEP standards when evaluating that plan approval, correct?
Correct.
Mass DEP, I think as we already covered, Mass DEP uses the AALs and the TELs, correct?
They use them, yes, as an incremental fashion on a specific source.
Is it your testimony that it would not be appropriate to apply Mass DEP's TELs and AALs to this air plan approval?
No, that's not my testimony. What I've been trying to say is that they have developed those guidelines specifically for air permitting, and they are to be used in just the fashion that they did in this case. I think there has been some interest to know what would be an appropriate standard for existing ambient concentrations that have nothing to do with the project. And so that the purpose of this paragraph was to indicate that there are such standards that could be looked at for that purpose, which is not a permitting purpose, and it's not related to how the Mass DEP used the AALs and TELs.
So, other health-based exposure guidelines are available that are more appropriate than the Mass DEP TELs for comparison with 24-hour ambient air concentrations to evaluate whether the measured 24-hour air concentrations are at levels of potential risk. So you said that other health-based guidelines are more appropriate than Mass DEP's TELs. Is it your testimony that other agencies' guidelines are more appropriate than Mass DEP's guidelines in this case?
Because the Mass DEP TELs and AALs are not meant for ambient concentrations. They're meant for the incremental effect of a specific source.
And so we'd apply them to the incremental source in your opinion, correct?
Yes,
And that would be an appropriate use, would it not, in your mind?
yes.
And there would not be other health-based regulations that would be more appropriate than using Mass DEP's TELs, correct? In your opinion?
No, I think for the air permitting purpose that they were used, they were totally appropriate.
So why did you write that other health-based exposure guidelines are available that are more appropriate than the Mass DEP TELs?
Because I'm talking about a different concept. I'm talking about ambient air concentrations due to all sources in the environment, not the incremental concentrations due to the source in question.
Throughout your testimony, you talk about the conservative nature of the AALs and the TELs, correct?
Correct.
You believe them to be conservative?
Yes.
They are the standards that Mass DEP set, correct?
Yes.
Whether conservative or not, they are the standards that the agency applies, correct?
I guess I wouldn't call them standards. I think they are the guidelines that the agency uses to judge the air permit for a particular project.
They are the allowable ambient limits and the threshold effects exposure limits that the agency applies, correct?
Correct, for a specific source.
Move to paragraph 76 of your testimony, Dr. Valberg. read that paragraph for us, please?
Now, paragraph 76 on page 21. Given that they are highly conservative screening guidelines, the exceedance of either a TEL or an AAL cannot be interpreted as indicating either the presence of unacceptable risks or the likelihood that an actual adverse health effect will occur. This is recognized by Mass DEP in its responses to public comments on the proposed plan approval for the Weymouth Compressor Station project, where they note that exposure above an AAL or TEL does not automatically mean that an individual will develop cancer or experience a non-cancer health effect.
When you say unacceptable risks, is it your testimony that exceeding an AAL or a TEL would not present an unacceptable risk?
I'm trying to give an explanation of what I believe is a policy of the Mass DEP, yes.
So you don't believe that exceeding an AAL or a TEL would pose an unacceptable risk?
Meaning unacceptable in the sense that there's an expectation that an actual adverse health effect will occur. They are the guidelines they use for looking at their air permit and judging the incremental impact of a particular source. And so that's exactly what they're for. And so if a particular source in its incremental impact has an exceedance, then that needs to be addressed more closely. But if the ambient level exceeds one of those numbers, then that's not an indication that that's an unacceptable risk.
Right, but if the emissions from a potential source here at project exceeded an AAL or a TEL, you'd agree with me then that it needs to be looked at least more closely?
It should be looked at more closely, but not even that exceedance does not mean that someone will automatically can expect to get a cancer or some other non-cancer health effect.
But it means it's exceeded what the Mass DEP, the regulatory agency, has determined to be the threshold for unacceptable risk, correct?
It has exceeded the agency's number for that particular specific source. That is correct.
And so in the case of formaldehyde, if you exceeded formaldehyde AAL, you've exceeded the threshold for unacceptable risk as set by Mass DEP, correct?
As set by Mass DEP, but as I point out in my in the rest of my report, that 1 in a million lifetime risk is exceedingly stringent, and that does not translate into risks that people normally would address in their everyday life.
1 in a million risk is what Mass DEP has said is the acceptable risk threshold, though. Do you agree with that?
That's the threshold they use for deriving the AAL numbers, yes.
It's Mass DEP's airplane approval, correct?
Yes.
No more questions.
Mr. Goldrosen?
Thank you, Mr. Valberg. I'm John Goldrosen, the Assistant Town Solicitor for Braintree.
Yes.
I'll try not to be duplicative, but if we could turn back to paragraph 66 beginning on page 17. Just based on what you said here today, do you think the Massachusetts guidelines are too stringent?
I'm really not in a position to judge what the agency would like to do for their guidelines. I mean, what I tried to lay out in my testimony was the basis of the guidelines to indicate that there were uncertainty factors and safety factors built in that really separated them by quite a bit from any particular health effect that they were based on. So, in other words, there's no demonstrated health effect at the levels of the AALs and TELs. The degree to which they want to incorporate additional safety factors, or for example, they do include the relative source contribution, which in a sense is another factor of 5 below the other typical guidelines. So I think they are very health protective, but as to how health protective they should be in comparison to other agencies, I'm not really a person to opine on that.
You think that's a matter of the, shall we say, regulatory judgment of the agency as to what the appropriate standard should be then?
I would leave it up to the regulatory judgment of the agency. I think that in terms of putting it in the context of other risks that we all face, I mean, that might be helpful information, but it's ultimately up to the agency to decide what the numbers are.
Are you questioning in any way the scientific basis or validity of the levels that the department has chosen? The 1 in a million standard?
I'm not questioning them. I think what I did in my testimony, or what I meant to do, is to lay out the process by which those particular numbers were arrived at. And they were arrived in a process that took a health effect and then extrapolated downward from the concentrations that caused that health effect. And it's a process that the other agencies use as well. They may have somewhat different so-called uncertainty factors, safety factors, extrapolation factors, and so on. So they may end up with different numbers, but the process is similar to what Mass DEP used.
All right. Let's turn back to paragraph 76 on page 21. You were previously questioned about. In the first sentence, you refer to the presence of unacceptable risks, and then you say, or the likelihood that an actual adverse health effect will occur. Those are two different things. Is that correct? And how would you describe the difference between risk versus risk? Forget the word unacceptable for a minute. Just what risk means versus likelihood that an actual adverse health effect will occur.
Well, they refer somewhat to the basis of the two numbers. As we had already discussed earlier, the AALs in the cases of those particular chemicals that are carcinogenic are based on lifetime risk. And so given the information we have either from human populations or animal experiments, you start with those and you project what the risk might be at a level where you would anticipate a 1 in a million lifetime risk. Now, that risk is by definition going to be very far below any actual experiment that demonstrated any cancer risk. And I think the Agency for Toxic Substances and Disease Control, ATSDR, does a good job in showing a chart where they show where the data is for cancer risks and exactly where the guideline levels that range from 1 in 10,000 to 1 in a million, how far down they are in concentration. So those are very low risks compared to our normal everyday risks that all of us experience for developing cancer. So that's where the risk context is in. That shows that those risks are extremely low. The TEL, because it's a threshold effect kind of number, that's where you would look at it more as an actual adverse health effect occurring. In other words, you get watery eyes, do you get a sore throat, do you get some sort of respiratory problem? And those threshold effect levels are also quite conservative. And you would not expect that if you were at that level or above that level that you would experience those threshold effects. In other words, they're unlikely.
All right. Let's turn to paragraph 34 on page 11, I believe. So this is your point that the level set for the AAL is well below any point at which there's been a demonstration or an experiment showing actual damage. But nonetheless, the guideline is based on risk. It's a statistical probability. It's not based on actual observation, is that correct?
They are based on extrapolation to a very low probability. And so, yes, the point is that they're far below where any demonstrated effects occur. And they, in fact, as I point out in my testimony, they are far, far below the type of cancer risk we experience just merely by being alive.
So if we turn to paragraphs 43 and 44 on page 13. So again, I don't mean to be repetitive, but the fact that the TEL is a multiple below what a demonstrated health effect is, you're making an observation there, but that's not the basis on which DEP has set the 1 in a million standard, correct? I mean, the 1 in a million is going to be well below any observed level, correct?
Right, but maybe I just should mention here on this particular section, we're discussing the TEL, which is a threshold effect level, which does not have that 1 in a million. This really is based on non-cancer effects. And typically, if you look at the pharmaceutical efficiency of drugs and the potential toxicity of drugs like aspirin, the borderline between a no effect level and a harmful level is much narrower than that. If you have a harmful level, if you back off by a factor of 10, you're typically in an area of no effect. So the kind of factors that are applied in this case are very generous, and they, I think they're highly protective.
Let's turn to paragraph 84 on page 25, beginning on page 25. Could you read the first sentence out loud?
Benzene and formaldehyde ambient air concentrations and cancer risks highlighted by the petitioner's pre-filed direct testimony as supporting the health harms posed by existing air quality in the Fore River Basin area fall within US EPA's acceptable cancer risk range, meaning that these hypothetical cancer risks should not be viewed as providing evidence of unacceptable existing air quality.
All right. So, and actually, as you mentioned just above that in paragraph 83, and you've used the term the EPA's acceptable cancer risk range. You mean by that between 1 in 10,000 and 1 in a million? Is that correct? I understand your use of that term.
Yes, for cancer risks, and that is their acceptable range. And in their acceptable range, the 1 in a million is the most stringent. It's the de minimis risk.
All right. But the Massachusetts limit, guideline, standard, whatever term you apply to it is 1 in a million, correct?
That's correct. That's the guideline they used for establishing the AALs. And again, what I'm talking about here is the concern about the health harms of existing air quality. And in that existing air quality, there I would argue that the guidelines having to do with ambient air quality generally are more applicable than the AALs and TELs, which are really these numbers applicable to permitting processes.
But in that first sentence of paragraph 84 then, at the end of that where you say these hypothetical, so the existing air quality levels, while they are within the Fore River Basin, while they're within EPA's acceptable cancer risk range, they are above the Massachusetts guideline of 1 in a million. Is that correct?
I guess I don't quite understand that. I mean, Massachusetts does not have a guideline that says ambient air should fall within 1 in a million cancer risk, lifetime cancer risk concentrations for air toxics. I mean, they don't have such a guideline that I'm aware of. the 1 in a million was used to develop the AALs for the specific purpose of permitting, and that's the figure they chose. But if you're going to be asking questions about ambient levels and things that people are exposed to on a day-by-day basis, then you need to look more broadly.
Well, so your statement that the risks within the Fort River Basin based on ambient air concentrations, quote, should not be viewed as providing evidence of unacceptable existing air quality. Is that based then on your understanding that Mass DEP does not have such standards for ambient air concentration for air quality?
That is my understanding, and in there I would refer back to what we were looking at earlier in paragraphs 67, 68, and 69, where ambient air concentrations were developed by various regulatory agencies, and those concentrations are not exceeded by Fort River air quality.
Right. I'll just ask one further question on if the standard for ambient air concentration is X, if the concentration is 2 times X, is the risk greater than if it's X? Does the risk rise with the level of the concentration of a particular air contaminant?
In the assumption used in cancer risks, I mean, where you have this 1 in a million lifetime risk and so forth, which is proportional in concentration, then by assumption, you're saying that yes, if the substance is a carcinogen and the concentration is twice as high, then you will have twice the risk. But you have to remember exactly where are you in terms of the scale of concentrations that agencies have set as being important for ambient air.
I have no further questions.
Mr. Hayden.
Thank you, Ms. Rothschild. Good afternoon, Dr. Valberg.
Good afternoon.
You're testifying this afternoon under oath, correct?
Yes.
What does that mean to you?
That means I put down what I believe is correct to the best of my ability.
It's more than that,
Or
isn't it?
truthful, yeah.
You signed your pre-filed direct testimony under the pains and penalties of perjury?
Yes.
What does that mean to you?
That means that, again, I'm giving the truth as I see it.
Have you testified before this afternoon in any case?
I have testified in other cases.
And did counsel review your pre-filed direct testimony before you submitted it?
Yes, they looked at it.
In any of the prior instances in which you provided testimony, have you ever withdrawn any prior testimony?
No, I can't recall that I've withdrawn testimony.
One instance in which you previously testified was a case involving Pam Collins, a 14-year employee of a GE light bulb plant in Bellevue, Ohio, correct?
Yes.
Ms. Collins wore asbestos gloves to work every day, and at 63, she was diagnosed with mesothelioma. Is that correct?
Yes.
You wrote an expert report in that case and opined that Ms. Collins' mesothelioma was not caused by wearing the asbestos gloves, but was instead caused by her smoking habit. Is that correct?
Yes.
Now, 1 year prior to that testimony, you were contacted by an attorney from the law firm of Tucker, Ellis, and West regarding collaborating on scientific literature to connect the diagnosis of mesothelioma with smoking habits, correct?
Well, the company was hired to look into the research on that area, yes.
Well, the company was hired by the same law firm that was defending the Pam Collins case, correct?
I think ultimately that, yes, they were defending that case.
And so as I understand, I can show you some email history if you'd like to refresh your memory. But in March of 2008, Evan Nelson at Tucker Ellison West reached out to you to ask if you could collaborate to publish several key revolutionary articles that you will see unfold as I present this to you.
I think that we were contacted by him. I do believe that's correct.
And you replied to Attorney Nelson saying that the articles and calculations he provided were very provocative. Do you recall using that language?
I could have, yes.
So to that point, mesothelioma was widely agreed in the scientific world to only be caused by exposure to asbestos, correct?
Yes, predominantly caused by asbestos exposure.
Okay. And this attorney reached out to you to author literature that created an alternate causal link to mesothelioma related to smoking, correct?
It had to do with radioactivity, and radioactivity is a universal carcinogen, yes.
And you published an article in the Journal of Environmental Radioactivity with Robin Pruitt and Julie Goodman on that subject, correct?
Yes.
And that article in the Journal of Environmental Radioactivity was financially supported by the same law firm that contacted you initially to do that research, correct?
They provided some support, yes.
Some financial support
Yes.
for that article. And in the report that you submitted in the Pam Collins case, where you took the position that her asbestos gloves did not cause her mesothelioma, but instead her mesothelioma was caused by smoking, you cited that Journal of Environmental Radioactivity report that the defense attorneys had provided financial support for you to author, correct?
I believe that's probably the case, yes.
It is the case,
It
right?
is the case, yeah.
More recently, you testified here in Boston in a case filed by Thomas Giancopoulos on behalf of a class against Philip Morris. Do you recall that matter?
Yes.
And the gist of that lawsuit that was filed in Suffolk Superior Court was a claim that Philip Morris was unfair and deceptive in advertising its Marlboro Light cigarettes to consumers on the basis that they were healthier for consumers than their regular Marlboro Red cigarettes, correct?
Correct, but there was never any question that cigarettes are harmful. I mean, that was not an issue in this case.
Okay. I could hand you this opinion.
Do you have a copy for?
I do have a copy for counsel, yes.
Dr. Valberg, may I see that from?
Sure.
For the record, Ms. Rothschild, this is an order from Judge Liebensberger of the Suffolk Superior Court constituting his findings of fact and conclusions of law after trial in the case that I noted for the record.
Dr. Valberg.
Dr. Valberg, if you could turn to page 17 of this document. The paragraph, first full paragraph beginning considerable. Could you read that for us, please?
Yes. Considerable time was spent at trial analyzing published scientific studies addressing whether light cigarettes deliver lower tar and nicotine to the smoker under various assumptions and protocols. The studies discussed included ones done before and after the class period, including two principal ones carried out by Philip Morris long after the class period. Dr. Shields testified that all the studies consistently support his opinion that as between Marlboro Lights and Marlboro Reds, there is no statistically significant difference in exposure to tar and nicotine to the smokers of the two brands. In contrast, an expert called by Philip Morris, Dr. Peter Valberg, opined that the studies done after the class period demonstrated that smokers of Marlboro Lights actually received lower tar and nicotine. Dr. Valberg's analysis of the data provided by the published studies was shown to be inconsistent and contrary to the consensus of the scientific community. Dr. Valberg's analysis has never been published or subjected to peer review. I find the testimony of Dr. Shields was far more persuasive and credible than the testimony of Dr. Valberg.
And that's the same Dr. Valberg, that's referring to you?
Yes, that's referring to me.
And you did not recant any of your testimony from that proceeding?
No, my testimony was correct. I think the judge misinterpreted the evidence.
And in that case, the court found that the plaintiffs had proven unlawful conduct by Philip Morris, which knew that the implicit health reassurance message that Marlboro Lights are less harmful or safer than Marlboro Reds conveyed by the descriptors lowered tar and nicotine and lights was not justified?
I think that's what they found, yes.
Dr. Valberg, if I could turn your attention to paragraph 109 of your pre-filed direct testimony. You address a statement made by Dr. Nordgaard in his testimony. Do you see that?
Yes.
I'm not going to argue with you about causality here because I think we will agree to disagree. But I'd like you to focus solely on the last two lines of paragraph 109, where you reference Dr. Nordgaard stating such concentrations and duration is potentially injurious to humans, animals, or vegetation. Do you see where I'm referring?
Yes.
Now, again, setting causality aside and accepting Dr. Nordgaard's qualifying language using the word potentially, do you agree with his opinion that emissions from the compressor station of such concentrations and duration is potentially injurious to humans, animals, or vegetation?
No, I don't agree because the air permit specifically addresses the concentrations being predicted by air dispersion for the facility, and those are in compliance with the AALs and TELs.
And I'm not making any reference to AALs or TELs. You agree with Dr. Baird's testimony that any exposure to genotoxic carcinogens increases the risk of cancer, correct?
If you assume that there's a linear no threshold model, yes, that's a sort of tautological assumption.
Okay. And again, making no reference to TELs or AALs, just talking about emissions of such concentrations and such duration, do they have the potential to injure humans?
I think with that linear model, you cannot prove there's zero risk. So I would agree, there's not zero risk, but the potential for risk is extremely small.
Fair enough. I'm not asking you to agree with me on causation, but at least we have some small area of agreement that because of the linear relationship and the nature of the genotoxic carcinogens that will be emitted from this proposed compressor station, the emissions are of such concentration and such duration that there is a potential for the emissions to injure human life.
With a large qualification for the word potential, yes.
Thank you, Dr. Valberg. I have no further questions.
Go off the record for one moment.
Dr. Valberg needs to speak into the microphone.
Okay.
A little louder.
The microphone
Move
needs
it
to
a
be
little
closer
closer.
to you.
Use the mic.
Use the microphone.
That's better.
Thank you. Any redirector, Dr. Valberg?
Just a couple of questions. Dr. Valberg, you testified regarding the use of the AALs and TELs, correct?
Yes.
Could you describe what other considerations you would expect the DEP to take into account if there were exceedances of the TELs or AALs identified in the model of a particular facility?
Well, if they did an analysis for this particular air permit that they are working on, and if there are exceedances, then they would try to adjust the project so that the exceedances did not exist.
Would they consider where the exceedances existed?
Yes, they would indeed consider that, because the issue of potential cancer risk is not only a combination of where the concentrations, what are the maximum concentrations, it's a question of, is there a population there? I mean, and how much time does the population spend in that area?
Would they consider the frequency of any such exceedances?
Yes.
Have you testified before in proceedings here at MassDEP?
Yes, I have.
And was your testimony accepted?
Yes.
And were the results consistent with your testimony? In terms
Yes,
of the
they were.
decisions by the department?
I'm sorry, yes, they were.
Thank you. I have no further questions.
Just one.
Any recross?
Go ahead, Mike.
I was just gonna ask, Dr. Valberg, how much are you being compensated for your review and testimony in this case?
I'm a salaried employee at Gradient. I'm not being compensated by the client. The client pays Gradient, and Gradient pays my salary.
How much is Gradient being compensated for your review and testimony in this case?
I haven't looked at the bills. I mean, I can't really answer that question.
What is your best approximation?
I think that the billing rate is around $400 an hour.
No further questions.
Mr. Bertram?
Thank you. Just a couple quick questions. You're familiar with who Mr. Justin Fickus is, Fickus Fickus?
Yes, I know the name.
I saw in your footnotes you reviewed his pre-filed testimony. Are you referring to the first set of testimony you put in?
I'm sorry, could you repeat?
Did you review any rebuttal testimony from Mr. Fickus, whatever you say?
I do remember reading it, but it's not really my area of expertise.
And you were just redirected on considerations for if something exceeded an AAL or TEL, and you spoke to frequency and location, correct?
Yes.
When you voiced those opinions, to what specific Mass DEP policies were you referring, if any?
I think that I don't know the frequency and duration are in that policy in particular, but in terms of the department's general charge, that they would attempt to make the impacts of the facility as low as they can.
But you're not, sitting here today, you can't refer me to anything particular in any policy, correct?
As to frequency and duration, I can't specifically know.
All right, thank you. I have nothing further, Ms. Rothschild.
Mr. Goldrosen? Any redirect?
No, thanks.
Thank you, Dr.
Okay.
Goldrosen.